So it's a work study to discuss steps and/or the process for an employee to take should they experience retaliation. That was a topic that I discussed with Susan before, and she'll have the appropriate presentation for that. So let me turn it over to her.
And I apologize again. There are 3 accidents in the 7 California off-ramp off of the freeway, so just have to say don't go out there for a while. Okay, I'm going to, one thing I do want to give you a caveat on is I'm not here to give legal advice on specific situations. For instance, if you have any pending matters or past pending matters, it would be inappropriate for me to opine in public because of the attorney-client privilege. So, having said that, I was tasked with the idea, or with the task of coming to you to talk about the various methods for reporting retaliation when an employee, in particular, experiences retaliation, or thinks they have experienced retaliation. What is retaliation? Well, the case law really is focused mostly on Title VII, and that is when you have filed a sexual harassment or discrimination case based upon gender, racial biases, and ethnicity. It's basically, case law comes down to that. And it's really three elements. Materially adverse employment decision. I'll get into what is materially adverse. Caused by the employee's engagement in a protected activity. So 3 elements. The case law is very clear. You have to have those 3 elements. Stated another way, you have this here in the presentation, and I'll make sure that you get copies. It's the same thing, only I put it in a different order. It's an activity protected under a statute. The employer imposed an adverse employment action, and there was a causal connection between the 2. What is protected activity? Reporting a violation of the law would be protected. A matter of public policy, that's a very broad concept, but it is a matter of public policy. Generally, in Arizona, management issues are not protected activity. They may or may not be, but generally they are not. In the Balma versus Trent case, which was decided by Judge Wake, involved the superintendent and the district in Globe. He said the content of whatever the complaint was is not a public concern. It deals with individual personnel disputes and grievances. The employee was upset about the salary schedule. He used the term internal power struggle, and he says, while the First Amendment invests public employees with certain rights, it does not empower them to, quote, constitutionalize the employee grievance policy. And he cited this case from San Bernardino. We are, by the way, in the Ninth Circuit. That has been a piece of chagrin for a lot of people. The Ninth Circuit is a big circuit. It's generally thought of as being more liberal than the other federal circuits, but it is what it is. We're in the Ninth Circuit. So the case law I've tried to cite to you is Ninth Circuit case law. What is reprisal? Now, reprisal is different from retaliation only in the term. Reprisal is used in the Arizona Whistleblower Act, and it basically, again, it's prohibited for an employee who has control over personnel actions to take reprisal against an employee for a disclosure of information of a matter of public concern. Now, that can be a violation of any law. It can be mismanagement. Generally, a gross waste of monies or an abuse of authority. Reprisal only comes into play in the Whistleblower Act, which I'll get into in a moment. And reprisal means to take a personnel action, the result of which is adverse to an employee that is caused by a protected activity. Where do we find the definition? Again, it's in the Title VII, mostly in the Title VII case law. And the term that the United States Supreme Court used in 2006 is that it has to be a materially adverse personnel decision. For instance, this is clear, there's what I will call black, white, and gray, but, and there's really more gray than there is black and white. I would say that it's pretty clear that firing and demoting are adverse personnel employment actions, or adverse employment actions for purposes of a retaliation claim. What is more gray is, and again, we're in the Ninth Circuit, which is extremely, has been known to be liberal in employment cases, more liberal than other circuits, is a transfer with no change in pay, may or may not be, effective demotions with no change in pay, and bad evaluations with no consequences. I am not saying that these are examples of materially adverse personnel actions. I am saying that courts have considered them. And this gives you some examples. Start at the bottom. I'm going to only touch on a few because of the limited time. Transfer where salary is unaffected is not, was found in the Ninth Circuit not to be a materially adverse personnel action. Now keep in mind that just because you have a materially adverse, I'm going to skip over these, you have them, but I'm going to just talk on this one just for a moment. The Motorola case is what we call the Motorola case. It's fairly important because it's of course in Arizona. And basically what it said is that under an employer policy stating that performance, skill, and or service would be considered in termination situations, the employer's termination decision based on service alone was legitimate. So again, you have the causation factor. You can make a materially adverse decision. So my law firm, or let's say it's a government entity, a city or town can decide that they are going to change somebody's duties that they perceive as to be materially adverse. But it has to be as a result. It has to be caused by something they did in exercising their constitutional rights. So, he failed to show causal connection between his protected activity and his discharge. Again, the court emphasizes cause. All right, what laws specifically prohibit retaliation? And I'm going to give you this caveat. I did not give you a complete list. I'm just touching upon the ones that crop up the most. The Civil Rights Act of 1964 prohibits retaliation. The Title VII, which is the discrimination, anti-discrimination. Title IX, which is gender bias in educational activities. The Americans with Disabilities Act. The IDEA, the Special Education and Services, and other laws specifically relate to civil rights. Discrimination do not allow retaliation if you complain that they were violated. In Arizona, we have a Whistleblower Act and we have the Employee Protection Act. The Whistleblower Act applies only to government employees. The Employee Protection Act applies to private sector employees as well. Okay, GPS policies. I have GBA, which if you all, for those of you who aren't here, aren't familiar with the policy coding and the way policies go, is that different letters of the alphabet are different topic areas. And G is generally employment, employee rights, employee procedures, and you have a GBA policy that prohibits retaliation for complaining. You have JB, which deals with students, and no retaliation for students, that if you complain of a discriminatory act. Here's GPS policies that provide mechanisms for reporting retaliation. First of all, I'm just going to say, you have a number of different areas where there are forms in your policy manual. There's a form in AC, which deals with discrimination, in ACA, that deals with sexual harassment. You have a form in G, you have a form in B, which deals with, I'm sorry, they don't have a form in B. But what I am saying to you today is the forms provide a way to hone in on the relevant information, but you shouldn't be married or require necessarily that a form, if someone forgets to add a certain piece of information, because you do not want retaliation, you want to get the information. Following the chain of command is the best practice. Again, for those of you who don't know, the Arizona School Boards Association, but also on a national level, the National School Boards Association has adopted prototype policies. And these are policies that you have adopted that are pretty much what the other school districts in Arizona have adopted and in the nation. And basically they do have procedures for following the command. Role of administration, we've gone over that in a previous work study, that administration is to administer the day-to-day operations. The role of the governing board is to administer the policies and also draft policies. Also remember, the governing board serves as a quasi-judicial officer. What does that mean? Well, you're not wearing black robes, but you do ultimately have to decide personnel actions. You cannot delegate it. So if you have personnel actions, you know that you sit as a judge. There may be a hearing officer who sends you a recommendation, but ultimately you're the judge. If you have followed it, for instance, about a year and a half ago, there was a big, highly publicized personnel matter in Peoria in which a young boy drowned in the swimming pool. The hearing officer said that that the coach or the PE teacher didn't commit negligence and shouldn't be fired for it, and the board overruled the hearing officer. Well, that's an example, because you can have hearing officers that say one thing and then you can overrule them, or you can uphold it. But ultimately, the board is the deciding body. So as a quasi-judicial body, you have to maintain what a judge might do. And those of you, I'm not going to get into specific legal advice, but you've heard me at law conferences and at other conferences, and you've heard other lawyers that practice education law say, you know, as a law, if you were a judge, you wouldn't meet or you wouldn't do one thing that the other side would perceive as being unfair. And so I constantly tell school boards in other jurisdictions at these law conferences, you remember you're like a judge. You're going to have to be fair to all sides. Okay, so what if the complainant maintains that the person doing the retaliation is their supervisor? Well, you do have policies in place that basically say chain of command. And I generally recommend that it go through the chain of command. Can you ever jump the chain of command? Well, if I assume that somebody could argue that, yes, we need to jump the chain of command, but it's in place for safeguards to stop behavior and to get them stopped as early as possible without having to go to the superintendent or to the school board directly. In addition, the danger in going to the school board directly, and I think this was part of the question, is that it may ultimately result in an employment action. And the school board is not only is going to have to make a quasi-judicial decision. So as it's important to go through the chain of command to keep the school board as detached in a judicial way as possible. Okay, so you have policies. You have BHC, which I believe I have in this course, yeah, which talks about the official communication between the board and employees will occur as follows. First, communicate at the administrative level, on the school level, and then if you exhaust your opportunity, you go to the next level, and then may communicate in writing with the board on the matter. No anonymous communication will be considered by the board. Any employee who wishes to address the board in the employee's capacity as a parent may do so with the procedures in place, and official communications and policies and directives will be communicated to employees by the superintendent. You also have GBK, which deals with employment and employee grievances, and I will jump right into that. GBK incorporates your memorandums of understanding with your various employee groups. And I will get to that. Sorry, I'm switching around a bit. You have grievance procedures in your certified agreement that have informal procedures, and then step 1, step 2, step 3, step 4, level 1. I don't know the word you use. Do you use level or steps? I can't remember. I have it with me, and I'm sorry, but in the interest of time, I'll move on. But anyway, you have a formal procedure and you have an informal procedure that you go through first, and then you elevate it. Same way with your support staff. These are grievance procedures that you as a board have agreed to in your bargain for memorandum of understanding. I probably should use it, right? KEB is the policy that allows members of the general public that have a concern or complaint. It allows members of the public to make their concerns known. Again, you have, I'm going to go back over the 3 general areas. You have policies. You have BHC, GBK, and KEH. And then you have the grievance procedures that are in your certified and your support staff manual. State laws, you have the Arizona Whistleblower Act and the Employee Protection Act that specifically tell how you can make a claim. And then you have the Arizona Civil Rights Act. If an employee feels that they've been discriminated against, they can file a complaint with the Arizona Civil Rights Division, and that includes retaliation based upon discrimination. You have federal laws and agencies. The Equal Employment Opportunity Act. If an employee feels that they've been discriminated against, again, they can go to the state Civil Rights Division, or they can go to the EEOC. There's the Americans with Disabilities Act that is administered by the EEOC. And then if a student or someone on behalf of a student has a grievance and feels that they've been discriminated against or retaliated against for filing a complaint or complaining about how a student's been treated, they can go to the Office of Civil Rights. In Arizona, we are in the division that goes to Denver, and they do an investigation. All right. I think I have almost exhausted my time, but I'm open to answer questions.
Okay, board members, we just have a few minutes. Is there any questions? Okay. No questions from board members?
Okay.
So will we email a copy of that?
Yes, Jennifer has a copy. I have one with me. So I brought an extra copy with me, but Jennifer can get mine out. Sorry, all right, thank you very much for inviting me. I hope this covered everything you had questions about. Any other questions? Thank you.
Okay, that concludes our work study, and we will adjourn to the board.